crucial judgment delivered today, the Supreme Court of India upheld the provisions of the Employees Pension Amendment Scheme of 2014 and set aside a judgment of the Kerala High Court which had quashed the scheme. However, so far as the present members of the fund are concerned, a bench of Chief Justice of India, Lalit, and Justices Aniruddha, Bose and Sudhanshu Dhulia has read down certain provisions of this particular scheme. Importantly, in a relief to several employees, the Supreme Court held that employees who have not exercised the option to join the Employees Pension Scheme must be given a further chance of 6 months to do so. The Supreme Court of India today also clarified that employees who were entitled to join the pension scheme but could not do so as they did not exercise the option within the cut-off date should be given an additional opportunity, as there existed a lack of clarity regarding the cut-off date in view of the High Court judgments invalidating the provisions of the Employees Pension Amendment Scheme of 2014. Therefore, the court exercised its inherent powers under Article 142 of the Constitution to extend the cut-off date. The Supreme Court further held as invalid the condition in the 2014 scheme that employees are required to make a further contribution at the rate of 1.16% on the salary exceeding Rs 15,000. The court was also of the opinion that this particular condition to make additional contribution on the salary exceeding the threshold limit to be ultra-virus in nature. However, this part of judgment has been kept in suspension for 6 months to enable the authorities to generate funds in the meantime. Essentially, the Supreme Court of India was pronouncing the judgments in the appeals filed by the Employees Provident Fund Organization and the Union Government, challenging the Kerala, Rajasthan and Delhi High Court judgments which had quashed the Employees Pension Amendment Scheme of 2014. Pertinently, the Supreme Court today in this particular judgment also upheld its 2016 judgment in R.C. Gupta versus Regional Provident Fund Commissioner, in which it was held that there can be no cut-off date to avail benefit of the option under the scheme. To provide a bit of context for our viewers who are unaware of this issue, the Employees Pension Scheme was amended in 2014 to increase the maximum pensionable salary to 15,000 from 6,500. However, it excluded new members who earned above 15,000 and joined after September 2014 from the scheme completely. Essentially, the Supreme Court bench was pronouncing the judgments in the appeals filed by the Employees Provident Fund Organization as well as the Union of India, challenging the Kerala, Rajasthan and Delhi High Court judgments which had quashed the Employees Pension Amendment Scheme of 2014. Pertinently, in this judgment pronounced today, the Supreme Court also upheld its 2016 judgment in the case of R.C. Gupta versus Regional Provident Fund Commissioner, in which it had been held that there can be no cut-off date to avail the benefit of the option under the scheme. To provide a bit of context for our viewers who are unaware of this particular issue, the Employees Pension Scheme was amended in the year 2014 to increase the maximum pensionable salary to Rs 15,000 from Rs 6,500. However, it excluded new members who earned above Rs 15,000 and joined after September 2014 from the scheme completely. Existing members had to decide within 6 months from September 2014 as to whether they wanted to exercise the option to make uncapped contributions. The amendments were subsequently challenged before various high courts of the country, leading to the present batch of appeals before the Supreme Court of India. The Kerala High Court, in its 2018 judgment, while setting aside the 2014 amendment to the scheme, allowed paying pension in proportion to the salary above the threshold limit of Rs 15,000 per month. The High Court had also held that there can be no cut-off date for joining the pension scheme. During the proceedings before the Supreme Court of India in this particular case, the main argument that was raised by the Employees Provident Fund Organization was that the pension fund and the Provident Fund are distinct and that the membership in the latter will not automatically translate into a membership of the former. It was argued that the pension scheme is intended for low-age employees, and if the persons drawing salaries above the cut-off limit are allowed to draw pension as well, it will create a huge imbalance within the fund. The 2014 amendments were brought to address the issue of cross-subsidization between the pension and the provident funds. However, on the other hand, the pensioners disputed this argument of financial burden raised by the Employees Provident Fund organization. It was argued by them before the court that the corpus fund remains intact and the payments have been made from the interest. The pensioners also disputed the argument of the Employees Provident Fund organization that there has to be a separate option exercised within the cut-off period to join the pension scheme, and contended that the stand of the Employees Provident Fund organization is contrary to the existing statute. For more information on this particular verdict, you can refer to a detailed report, the link to which has been given in the description box below. Thank you. I'm Aratrika Bhaumik for Live Law. Keep watching Live Law for more such updates.